So why are you homeless? Like, when does this start? Have you always been homeless?
The point of beginning to now, I'd say I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I had no excuses to give you, and I present them to you. And now I do have a reason, a purpose to stay off probation, to pay for myself, meaning invest in myself.
For the state,
Jason Garrett, hand your honor.
defense,
Charles Gold from Mr. Bishop.
and are you Mr. Bishop?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, your honor.
Court will find that the state is in compliance with discovery. Mr. Bishop, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that with your attorney?
Yes,
Did
ma'am.
you understand it and did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, your honor.
State, are you proceeding on the indictment as presented?
You are, your honor.
Mr. Bishop, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of stalking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial,
Yes,
a
ma'am.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, your honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I think he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, your honor.
Mr. Bishop, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I believe so.
Well, I mean, either you are or you're
Yes,
not.
ma'am. Yes, ma'am. Sorry.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 727710. There's to be no contact with Tricia Robles, and you're not to be within 500 feet of Tricia Robles, and you're not to go to McDonald's at 101 Alamo Plaza and be within 500 feet of that location.
Yes, ma'am.
Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, your honor.
State?
That is, your honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, your honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Tricia Robles or McDonald's at 101 Alamo Plaza. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, your honor. State exempt from one with all attachments. No objections, your honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate
Yes,
places?
ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. States exhibits 1 and attachments. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. I would like to address the court about the fine.
Yes.
He's homeless. We would ask that you probate the fine, all of the fine, until he gets a job or gets set up. We would ask, since he's been homeless.
All right. Why are you homeless?
Just doing things for my community, the homeless community, being an activist and preventing.
No. Why don't you have a place to stay?
I guess for people's sake that I don't like being a burden to anybody.
No, I mean, if you get a job,
I know.
no, here's the thing. Listen,
Yes, ma'am. Yes, ma'am.
if you get employment and get an apartment and pay the monthly fee for the apartment, guess what? You're not a burden. It's a business transaction. So why are you not engaging in business transactions for a place to live?
I have no excuses to give you. I'm in the process of getting that together.
So why are you homeless? Like, when does it start? Have you always been homeless?
The point of beginning to now, I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I have no excuses to give you, and I present them to you, ma'am. Now I do have a reason, a purpose to stay off probation, to pay for myself. I mean, invest in myself.
Okay, counsel, do you know why he's homeless? I mean, sometimes people are homeless because they start using drugs and people are just done and they say,
I think during the time, Judge, no, not necessarily.
I've been sober for about going on my 13th year. I've never done heroin. I probably smoke weed for my anxiety. Because I do have bad anxiety. A drug problem. I'm too poor to have a drug problem. not to make fun or anything.
Yeah.
I just don't have the money to invest into a drug.
so I'm trying to figure out how can he do well on probation? What is his plan?
To get myself on the ball for probation.
But
That's
how are you going to do that?
getting a job, if it even means for right now, getting paid on,
Didn't you say something about Haven for Hope?
yeah, Haven for Hope, or the means to an end to get a job. I mean, that should be easy.
All right,
A purpose? Well, I had no purpose. I had no family to speak of, no kids to speak of, nobody to take care of. And when it comes to investing in myself, well, now I have a reason. So if you give me a chance, of course I'm gonna do what's right. I always do what's right.
all right, so here's the thing. No less than 2 times, this person at McDonald's said that you've been bothering her and she doesn't want you there anymore. Is GPS appropriate in this case?
At least additionally, it should be, Your Honor.
I don't know about that, Judge. I think wasn't this filed at large and there was nothing going on at the time?
No, I really every time she says the name, I really can't picture who the person she's speaking.
Well, it's the person where you keep going to McDonald's at 101 Alamo Plaza. She said you were trespassing. She didn't want you there. And it says, victim advised that the same patterns of malicious behaviors were directed towards victim by suspect. That's you.
Yes, ma'am.
They're saying that you would criminally trespass from the restaurant and would typically direct these gestures at her through a large store front window from the sidewalk. These behaviors occur several times a month and cause her to feel unsafe and anxiety. And then that was in August, and you also have the one from October. So I think he needs to be on GPS. How old are you?
20, I'm about to be 52, ma'am.
Yes.
If I really don't need to be on GPS because I really don't have nothing bad against her. She's a manager at McDonald's. Maybe I flicked somebody off through the window that was in there, but really,
All right. See, why are you telling me that she's the manager at McDonald's and you just told counsel you don't even know who she is?
Well, I don't know who she is personally to say, but I know after speaking to her, when she gave me, well, yeah, she's the yeah, one of the managers at McDonald's.
Judge, I just think that, I mean, we can delve into this, but I think that he's homeless, and I think, I'm asking about the fine. And if we can waive that, and I don't think how he's gonna pay for GPS. I think that can graduate if we need that later on, but there's been times when it hasn't. I say he's gonna be washed over for a while.
He needs GPS. I mean, I understand the situation that people are homeless. I do. But that doesn't give everybody a pass to do whatever they want to do.
Can you give me a chance to prove myself before you put me on monitor?
No?
But then, don't I need to pay some residents for a monitor?
What I'll do is we'll see if the fees can be waived, but you need to be on GPS monitor. And we can't do a wait and see if you're going to do well or not, because if you're back at that McDonald's, I want to know about it.
Okay,
And the only way to know about that, because you say you're homeless, is for GPS.
so the
And do not cut off this monitor. You understand?
so the GPS is just to see if I'm in the area of the place?
Yes. What type of GPS do y'all want? Partial tracking?
None.
Oh, it's gonna be GPS.
I believe at least tracking, so that, I mean, if he is homeless, obviously, that he should be. I think the state's position is that this particular McDonald's, this particular individual was scared for her safety. And I don't know if you read in there, Judge, is that one of the times this happened, an officer was standing with this individual when it happened.
Mhm.
And so that's the brazenness of that in front of an officer is more concerning to the state. You also, John.
Can I speak on that?
I don't know. Does your attorney want you to speak on that? All right, it's a $1,500 fine. That'll be probated. 7 years deferred adjudication. There's to be GPS tracking. No contact with Tricia Robles. No contact with McDonald's at 101 Alamo Plaza. And you're not to be within 800 feet of McDonald. I'm sorry, you all asked for 500 feet. I think it should be 800. Any objection to it being 800 instead of 500 feet?
I wouldn't know
No
where.
problem.
Okay. And you're not to be within 800 feet of the McDonald's at 101 Alamo Plaza or Tricia Roberts. I'm sorry, Tricia Robles. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a TAP evaluation in custody. My understanding that's 2 weeks. Follow TAP recommendations. Field visits. 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? Yes. All right, and then there's 200 hours of community service restitution. That'll be waived if you are able to get a certificate or some type of education from a trade school or somewhere else. You understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
I believe I'm being released on, I have to monitor.
You are going to be in custody for 2 weeks for a TAP evaluation. Anything else that you need to be successful on this probation?
So I'm gonna be put back in jail for 2 more.
Yes, you are. Anything else you need to be successful on this probation?
Okay, so do I have a?
Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Partially,
All right,
So-
what don't you understand?
when I'm gonna be released.
What I told you is you're gonna stay in custody
Mhm.
for the TAP evaluation. Once the TAP evaluation is done, if the TAP evaluation recommends that you go into inpatient treatment, you're going into inpatient treatment. If the TAP evaluation recommends that you be in outpatient treatment, then you will be released.
Okay, and that could be up to 2 weeks.
It depends.
Okay.
All right, thank you. Stay away from there. You understand?
Yes, ma'am.
Are you Mr. Ford?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ricky Darnell Ford who was placed on deferred adjudication in 2021 CR 1785 for the offense of aggravated assault with a deadly weapon on March 11, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violated condition number 5 in Bear County, Texas, the defendant Ricky Darnell Ford, the then there failed to report to the supervision officer as directed for the months of December 2023, January 2024, violation of condition number 5.
All right. How do you plead to that? True or not true?
True.
Your Honor, will waive the remaining violated conditions.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, the Move to deny the motion, continue the individual on probation for deferred, include, amend the alliance to state ISF program with cognitive, in a one time a week, for the duration of his probation, and monthly drug testing for the duration of his probation.
All right, is that the agreement?
It is, Judge. We asked the court to follow it. He was doing remarkably well. He just fell out of contact and stumbled, which happens unfortunately. We're hoping the court sees fit to give him a second chance.
All right. Probation? All right, I see on this case, there was previous McMile evaluations. So where are we? Right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God?
Yes, ma'am.
All right, you lower your hand. State your name for the record.
Ricky Ford Jr.
All right. Is there a reason your eyes are not open?
No, I'm fine, ma'am.
All right, so yeah,
Yes, ma'am.
you need to make eye contact. So were you doing well when you were on the MIC caseload and then you fell off after you were off the MIC caseload?
To be quite honest, I was doing well on probation. I was doing well, period.
Mhm.
I left here January 19, went to DDRF, finished the program there. Went to pay for it, finished the program there. I was doing well on my probation. And I lost my job and became homeless. The only thing, just to be quite honest with you, is he gave me a timeline between this time and that time to come back and see him again. But I guess we just got cross-communicated, so. But yes, ma'am, I was.
So here's my question for you. You lose your job, you become homeless. Did you call probation and say, I've lost my job and I become homeless?
Yes, ma'am.
And what was the response?
Come and see me when you get a chance. And I did that as soon as I got a job, came and saw him, let him know everything he asked me to do.
So if you did everything he asked you to do, why are we here?
They put out a warrant when they told me about the warrant. The warrant was put out on February 6th. To be quite honest, I went on November, saw him in November. I wasn't supposed to see him again until February the 27th. I have that in my property in a police impound in my tote bag. If I could have grabbed that, I would have showed you. I was supposed to take a TAPS test, but he was gonna give me a TAP evaluation. But I got that, since I guess I didn't see my case manager. She the one that put out the MTR for me. Cause she told me if I didn't see her again, she said, I'm gonna court you, so here I am.
Okay. All right. Do we have a tap for him or no? All right. Do you have a place to live?
Pay for hope.
All right. So this is what we're going to do. I'm going to deny the motion. Alter the main conditions to include a TAP evaluation in custody. Follow all TAP recommendations. We can do also a referral to felony drug court. Maybe they will take him because he has the dual diagnosis. If they don't take him, then maybe lifetime recovery, because if he was in the pay it forward program, maybe lifetime recovery, their inpatient treatment will accept him. So let's do a TAP evaluation while in custody. And then let's try a referral to felony drug court. And then lifetime recovery is number 3. And then we'll do 90 sober meetings in 90 days. Oh, what's wrong with you?
I did the bees before, it's like 90 days, so it's like wrapping my head around that.
All right, yeah, so you need to do that again, okay?
That's well.
And see about putting him back on the MIC caseload if he's not accepted in felony drug court. Okay, all right. All right, is there anything else?
No, ma'am.
Anything else from
In State of Texas versus Ricky Darnell Ford, a man already on deferred adjudication for aggravated assault admits he violated probation by failing to report. He explains he lost his job, became homeless, and communication broke down with probation. Instead of sending him to prison, the judge denies revocation and gives him another chance, ordering a TAP evaluation in custody, substance abuse treatment, and a possible referral to felony drug court. One last chance to get help before prison becomes the only option. Like, share, and follow for real court cases explained in simple words.
talking behind the court reporter? Because we're on the record. Court is calling 2020 CR 10218, State of Texas versus Jesse N.O. Can I have parties announced for the record for the state?
Allie Jackson.
Defense?
John Reitmeyer.
And are you Mr. N.O.?
Yes, Your Honor.
All right, this is a motion for a new trial. State, have you had a chance to review the motion?
Yes, Your Honor.
All right, defense, it's your motion.
Well, Judge, we filed a motion for new trial on this matter sometime well after the verdict. By dumb luck, really, I was speaking with another attorney, and he informed me that there was a previous disclosure from the state about one of the testifying witnesses, Dr. Kellogg. I had never seen that before, and I went through everything that we had on e-discovery. Did not see any disclosures that were made to me about Dr. Kellogg, and I was informed that there is, what I saw, there was at least one, there should be more.
And what would this disclosure be?
I have it, Your Honor. I pulled it from the physical file. So it was in the physical file when we pulled it from archives, but I do concede that it was not uploaded into Veripic, so therefore it would not have been part of the discovery acknowledgement when I looked.
Okay.
So our contention is this disclosure about Dr. Kellogg relates to previous testimonies that could have proved useful to cross-examine her differently about other cases that she had testified in.
And I'm going to provide it.
All right, would you all like to mark this and have this admitted into evidence?
We would, Your Honor. We're operating this as defense one.
All right, being offered into evidence for purposes of this hearing is defendants exhibit number 1, It's a memorandum of disclosure as related to Dr. Nancy Kellogg. Is that correct, State and Defense?
Yes, Your Honor.
Yes, Judge.
Okay. All right. Any other evidence, defense?
No, Judge, that's it. Just argument.
All right, the court will hear argument.
Judge, our argument is simply the state had is required under 3914 of the Michael Morton Act to provide disclosures such as that to the defense prior to trial. We did not have a chance to look at it. We didn't know anything really about it. And since it's under the state's control and custody, we had no way of obtaining it. Our argument is that affected my client's rights, and we're asking for a new trial.
State.
Yes, Your Honor, I'm providing case law. It's going to be 353 Southwest 3D 797 from the Court of Criminal Appeals. And it just lays out the prongs that you look for in this case when it's going to be a motion for a new trial for a Brady. The first prong is that the state failed to disclose evidence regardless of prosecution's good or bad faith. We do concede that it was not turned over, but when you look in the law that kind of helps talk you through it, starting on page 11, part of that first prong is that it was not disclosed, but also that the defendant could not have accessed it from other sources. In this case, this is a well-known disclosure. It's been around for years. And the first thing that you see when you Google this witness, Dr. Nancy Kellogg, as you often do when you look at an expert witness, you see multiple articles that actually provide even more information than the disclosure, both on the first page. And then if you hit news, all of the articles that are listed are about this disclosure with more details. So that's the first prong. The second prong is that the withheld evidence is favorable. We can see that, Your Honor. This would be for purposes of cross-examination. So the second prong is met. I think the first prong is shaky, but finally the third prong that must be met is that the evidence is material and that there is a reasonable probability that had the evidence been disclosed, the outcome of the trial would have been different. Now, in looking at and evaluating whether or not the outcome would have been different, you look at the entirety of the testimony that came out during trial. In this case, Dr. Kellogg was not a fact witness. She did not prove any of the elements. All of the elements, like elemental testimony, came from the victim and came from the outcry witness, Sam Abrego. Dr. Kellogg's testimony was very limited because she did not perform the SANE exam, and she testified she did not perform it. She just observed it. She testified as to what a SANE exam was. That one was performed, that there were no physical findings, and that no physical evidence was taken. All she could say was that it doesn't go against what the victim was saying, but she also could not say it definitively happened. So her testimony was not material, and the ability to cross-examine her on this would not have changed any sort of defense. The defense was always, this did not happen. The victim's lying, and that was what the defense would still be, because here the evidence showed, and she conceded, well, I can't say definitively whether it showed or not. And being cross-examined on this would continue to show the same defense. I can't say whether this happened or not. So because of that, while it was not given over, going through the three prongs of what a Brady violation results in a new trial, we do not feel it has been met. So we would argue against a new trial.
All right. And the court will note in defendant's exhibit number 1, it does state that there was a study that was published in 2007 as it relates to any testimony that Dr. Nancy Kellogg had given. So am I correct in assuming that this disclosure has been around since 2007?
I believe it's been more around 2013. If you look further in the disclosure, it says that in 2013, she gave an interview, or she spoke to the district attorney's office when they confronted her about that study. And it was in regards to the San Antonio 4, which is what all the articles reference to. And that's when she said, I'm aware of this new study, I'm aware of the new science, and my testimony would have been different if I were to do it now.
All right. So counsel, the state has handed over a case law regarding Pena. Do you need a chance to review that?
If I could, Judge.
All right, because since we've already started the motion for new trial, the motion for new trial can be continued on a different date if you need time to
And Mr.
gather
Reitmeier,
case law.
Application of the law starts on page 11.
Yeah. So if you would like to review that and maybe come with your own case law, I can recall this.
Could we do that, Judge?
Sure. What is best for you?
Not tomorrow.
No, no, no.
I can make it work just almost any time.
All right. Do you all want to do it the week of April 1st or the week of April 8th?
Either of those work. The week of April 1st might be better for us, Judge. We
Okay.
might be less than busy in traffic.
All right. So
That's fine. We can do that.
is Monday the 1st okay?
I can
Or
do it.
either Tuesday, the 2nd?
Tuesday is probably better for me, Judge.
All right. Ms. Ferguson, we're going to recall this for April 2nd. And then if you have any case law, if you could email it to the state.
Absolutely.
All right. Is there anything else?
Not right now, Judge.
All right, Mr. Inaho, we'll come back on April 2nd. So they're not going to transfer you. You'll be here on April 2nd, okay?
Yes, sir.
All right, thank you.
Thank you. I hear you.
All right, court is calling 2023 CR 9122, State of Texas versus Alex Espinoza. Could I have parties announced for the record for the state? Defense?
Jason Todd for Mr. Espinosa.
And are you Alex Espinoza?
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
I did, Your Honor. I did receive it and I did review it, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Espinoza, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did. I understand.
Did you review the document entitled True Bill of Indictment with your attorney? Did you
Yes.
understand it?
Yes,
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
yes,
Mr. Espinoza, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
yes,
Did you understand you're charged with the offense of evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
yes,
I need to speak up.
yes, ma'am. I do understand.
All right. If you have a plea bargain agreement with the state, court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand by entering this agreement, you were giving up those rights?
yes,
Did you intend to give up those rights and enter into a plea in this case?
yes,
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
yes,
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Espinoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
no,
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
yes,
According to the plea, there's a $500 fine. State recommends deferred. Is that what you understand the plea to be?
yes,
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your term of probation be for 8 years. There be a TAP evaluation, 100 hours community service restitution, ignition interlock for half the term, DWI education or intervention. What is this? You just have DWI VIP panel.
Yeah, I don't know what, we can do education, Judge.
All right. So DWI Education and Victim Impact Panel. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers exhibit one in all attachments.
No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. After reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just had one request regarding the conditions. Other than that, we have nothing else to say on behalf of our client.
All right. Mr. Espinoza, are you employed?
Yes, I am.
What do you do?
I'm a mechanic.
Do you have any children?
I have a son,
How old?
26.
All right. Does anybody want to speak to the length of probation?
Judge, we have negotiated extensively, and this is the offer that the state has given us, and we appreciate the deferred. This was the best offer that they had.
All right, then it'll be 8 years deferred.
The conditions wise, we're asking for the judge to not order the DWI conditions, as it's not a DWI. And it's just the principle behind it that it is innovating. He is willing, if there's other things the court wants him to do regarding community service or a fine or some other adjustment, we would understand that. And we're just asking not to have the DWI conditions.
Judge, so he was pulled over for suspicion of DWI. The officer was in the middle of the DWI investigation. That's when the defendant decided to jump in his car and drive away, where he was able to get away from the officer. He was doing that to avoid.
All right, it says, I attempted to conduct the HGN multiple times on suspect one. And once I was able to complete HGN, I continued to try to interview S1. So, I mean, in the police report, it appears that he's completed it.
That's my understanding.
So do we know the results of that or no?
No.
All right. All right. I don't have anything before me in the police report that says this was a DWI. Usually you pull somebody over, usually there's something in the police report that says he smelled of alcohol and intoxicants. I don't have that. I don't have anything. All right. So $500 fine, 8 years deferred adjudication, proof of employment within 30 days, no employment as a home health care provider with minors. Do a TAP evaluation out of custody. Follow all TAP recommendations. There should be regular reporting by Zoom or in person. There should be regular UAs, field visits, one time per month for 3 months. And the defensive driving course. And 200 hours of community service restitution. Probation, is there anything else?
You give me that 8 years deferred?
Yes, 8 years deferred. Proof of employment within 30 days.
No, that's everything.
All right. Is there anything else you need from the court? Yes or no?
No.
Okay.
No.
Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, so now I have two motions. One is a motion to return property, and it's the defendant thing we have is motion to allow the defendant to travel. And he wants to travel. His son has an appointment in Colombia in April for hernia repair.
Judge, we leave that at the discretion of the court.
All right, he's going to be gone April 15th through the 20th.
Yes, Your Honor, and I believe in the way it's drafted, so there's an attachment with the return flight. It's not, I
Yes.
did bring that today, so I apologize for that.
All right, so if you bring the attachment, then the court will allow him to travel, or do you have it with
May I
you?
present it to you, Your Honor?
Yes. Does he have something saying that his son has a hernia repair appointment?
I do not have that with me today. Your
All
Honor.
right, once you all receive that, then and present it, then the court will grant it.
Thank you, Judge. We'll reapproach.
All right, thank you.
May we be excused?
You'll need to speak with probation, then you're excused.
Thank you, Judge.
You're welcome.
In State of Texas versus Mr. Espinosa, the defendant is charged with evading arrest with a vehicle, a third-degree felony. He pleads no contest, and the judge accepts deferred adjudication instead of prison. He receives 8 years of probation, a $500 fine, community service, drug testing, a TAP evaluation, and strict reporting rules. The judge removes DWI conditions after finding no clear intoxication evidence. One mistake could still send him to prison. Like, share, and follow for real court cases explained simply.